Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing of gum, reading any materials, or driving. Thank you.
Thank you, Officer. And good morning to all. This is case number 22-177-828. This is Dr. Borakara, doing business as Michigan Pain Specialist versus Citizens Insurance Company of the Midwest. Today has been set for a pretrial in this matter. Your appearance for the plaintiff, please.
Good morning, Your Honor. Doug Harris-Gavich, P81458 on behalf of the plaintiff.
All right, thank you, counsel. Good morning to you. For citizens, if you will, your appearance at this time. Looking for counsel for citizens. Looks like I see, well, maybe not. Counsel, have you spoken with anybody that may be on the other side of this today?
I have not, Your Honor. I'm actually covering this for a colleague. I don't see them in the courtroom, though. I can give them a call right now and you can recall. Yeah,
let's make sure they're not there. Okay, counsel, just let me know. I'll stand down on that one and we'll come back to it. I am calling now the case that relates to Dr. Borakara versus Citizens Insurance. If you're counsel on that matter, please say something at this time. All right, we'll come back to it, counsel. Let me know. Give me a signal when you're back. Right.
Okay, I will.
All right, the court now calls case number 22-192-469. This is Jefferson Capital Systems LLC versus Sheila Gibson. The matter is before the court. Looks like I have this set up for a scheduling conference, or I set it for a scheduling conference in December, and it might have been adjourned. Your appearance, please.
Good morning, Your Honor. Michael Bankstein, P69778 on behalf of Jefferson Capital Systems.
Thank you, counsel, and good morning to you, sir. I'm looking now for Ms. Sheila Gibson. Say something.
Good morning. I'm here. Good morning.
Good morning, Ms. Gibson. Thank you. All right, I have received the answer in the affirmative defenses here. It looks like there may be an attorney. You're represented by counsel, are you, Ms. Gibson?
Yes. I don't know if he's here, but yes.
All right, let me see where. Do I have counsel for Ms. Gibson? If you're on the Zoom, please say something at this time. All right, when's the last time you talked with your attorney, Ms. Gibson?
That was actually, I want to say Monday.
Okay. So he knows to be here, correct?
Yes.
All right. All right. So I'll call you. I'll come back to your matter shortly. Let's give him a moment to get in.
Okay.
Thank you, Your Honor.
Thank you.
You got to get to Mr. Henning's number and information. Because maybe you can reach out to him while we're waiting to see if we can get him in here. All right, the court now calls case number 22-194-600. This is Midtown RX Pharmacy versus City of Detroit. The matter is set before the court for a status and scheduling conference. The court, I believe we received an answer to the complaint regarding this matter. All right, your appearance for Midtown, please.
Good morning, Pradeep Savantha Nathan on behalf of the plaintiff. Thank you.
All right, your P number, if you will, counsel, for the record.
Yes, 70094.
All right, thank you, counsel. Good morning to you, sir.
Good morning.
Detroit, your appearance at this time, please.
Yes, good morning, Your Honor. Mary Beth Hobbs, P40080, appearing on behalf of defendant City of Detroit.
Thank you, Ms. Coleman. Good morning to you as well. I know this is at the line. Has there been any discussions, or is this one where the court should normally set this on its normal course, allowing some discovery and somebody talking?
I think if you set it on its normal course, we'll be able to wrap it up through mutual negotiations. This is a very small bill that we're discussing in the grand scheme.
All right. Thank you, counsel. Makes sense to you, Ms. Collins?
I was about to say, Your Honor, yes, that's correct. I've worked with SIVA Law quite frequently. I believe we'll be able to resolve this matter.
Very well. So what I'm going to do is I'll go ahead and set it on for, I'll set it on a 60-day discovery and set it for pretrial at the end of that period of time. And so that's going to bring the matter back before the court. I'm going to go ahead and set it for the 16th, actually. March. So it's a little short of that time. We'll take a look at it and see how things are by that date. So March 16th, and I'm setting it on for 9:30 a.m. You will get a scheduling order from me in mail, and it will have discovery open through the 16th of March. It will also allow under paragraph number 6 file motions if you wish to do so, and setting them for hearing on that date as well. It has a short way of the other side, 10 days notice of your motion. I will hear it on the 16th of March. So you'll get that order in the next few days. Good day to the two of you. I wish you well.
Thank
Your
you
Honor.
very much. Appreciate it.
Thank you. All right, is Counsel for Ms. Gibson present yet? Just looking to see if the person might be there. Counsel for Ms. Gibson? I know that on Michigan specialist, have you seen anybody from Citizens yet?
I just spoke with the attorney record. She said Mitchell is handling the case. He's just logged in.
All right, got it. All right. And that's the subject 7828. And Counsel for the Plaintiff has indicated his appearance regarding this matter. For Citizens, your appearance at this time.
Good morning, Your Honor. Mitchell Talaki here on behalf of Citizens. I apologize. I had the wrong Zoom information on the notice.
Not a problem, sir. Thank you. That has been a little bit of a problem. Indicate your V number, if you will, for the record, sir.
Oh, no problem. P84962.
All right, thank you, Counsel. All right, so where are things? I know at one point there was an issue with getting an IME taken care of. I did set a scheduling order in this matter, and discovery should have been completed by now. Somebody update me on where this file is this time.
Your Honor, we did have an issue with getting claimant to appear for an IME. We had to file a deck action. I believe that matter has been resolved. We are just currently awaiting the report. We received plaintiff's responses to discovery, I think, last Monday, and we've gone through them. I think we might be requesting a little bit of supplemental discovery, but otherwise, I think that's where we're at with discovery in this matter.
Counsel, anything?
Everything said was correct. I believe we will be requesting a claim file. We haven't received that in this matter yet, but other than that, there just needs to be a review of that, their review of our discovery, and see if there's any supplemental needs, and then move on from there.
All right. Well, it sounds like you're moving on, moving forward expeditiously, and that there are no hangups. So have you talked, or have you gotten to the place yet where you can talk about a resolution, or still in the information gathering stage?
I don't have any notes that there is any attempt or any movement towards facilitation. I believe there was a demand that was made.
I believe I do have a demand here, Your Honor. I think we're closing up on finishing discovery in this matter, and then we should hopefully be able to move to resolution.
So I'll go ahead and set it up for a final pretrial conference. You look close enough. It seems that you're close enough for that. And I'm going to go ahead and set that for the 27th of February, 2/27, 23. And I'll set that at 9 o'clock, strike at 9:30 a.m. At that time, we'll look to see whether or not this is moving in the direction of some resolution, or whether I need to think about setting it up for some trial date. I think that you've moved along. We even got that IME issue resolved, so I'm optimistic that the time is given, we may be able to get this position to know what should happen. So the 27th of February, 9:30 a.m. That's the next action date. Thank you, gentlemen. Good day to you.
Thank you,
Your Honor.
The court now calls case number 22-194897. This is JGA Acquisitions Incorporated versus Keisha Davis. The matter is set for a scheduling conference on today's date. The court has received an answer in this matter. And I noted in the answer that the defendant indicated that she broke the lease, but she paid it off. Look at this matter is for some $2,146. All right, your appearance for the plaintiff in this regard, please. For JGA Acquisitions, if you're on the Zoom, please say something at this time. For Keisha Davis. All right, I'll return to that matter. No one has responded, although the matter is set on for today's date. Right, the court now calls case number 22-198219. This is Albion Funding versus Cynthia Jenkins. The matter is before the court set on for a staff conference. Your appearance for LBND Funding, please.
Good morning, Your Honor. Navjot Francis, P72322 on behalf of plaintiff's attorney of record.
All right, thank you, Ms. Francis, and good morning to you, Madam Counsel. Cynthia Jenkins, if you're on the Zoom, say something at this time.
Yes, good morning.
Good morning, Ms. Jenkins. I see that in this matter, there was a review regarding the settlement offer regarding this matter. And I think I set it up to come back with a certain number that the court had even proposed regarding this matter. Somebody update me at this time, please.
Your Honor, I did get a response from my client. We are willing to agree to the proposed settlement. We would require for it to be on a judgment with the full balance. However, if defendant makes the payments as agreed, then we would settle it for that $1,600 that was stated at the last hearing.
All right, and Ms. Jenkins, you understand that they're willing to go along with the $1,600 amount. The judgment would enter for the full amount as long as you pay the terms agreed. You only have to pay $1,600, and that would be the end of this case. You understand that, ma'am?
Yes, I could barely hear you, but yes, I had a question with her about the agreement.
All right.
The amount.
Yeah, the amount that was talked about was $1,600. Have agreed that they will accept the $1,600, therefore reducing the overall amount. But the judgment would enter for the full amount, but as long as you pay the $1,600 according to the agreement, then the rest of it would be dismissed and waived. You understand?
Yes.
And I believe that.
Go ahead, Ms. Francis.
Sorry. And the payment terms we discussed last time, they were $40 per month beginning February 1st, and then they would increase to $100 per month beginning May 1st.
That's what I had a question about, because I'm currently on a repayment plan with my mortgage, and I was wondering if we could keep the amount to the $40 until May, until I get that paid off, and then I could increase it after then.
That was the agreement. $40 starting February 1st until May 1st, when it increases to $100.
Okay, May 1st. Okay, that's what I wanted to verify. Okay.
Yeah, that's a part of the agreement.
Okay.
As long as you make the $40 a month starting in February, and then pick up to the $100 a month starting May 1st. Once you pay $1,600, that will be the end of it.
Okay, thank you.
Ms. Jenkins, do we have your permission to sign the consent judgment?
Yes, ma'am.
All right,
Yeah.
and I will sign the order consistent there with Madam Clerk. Where will she send that? You have a,
Yeah, she can send it to my email address.
oh, I thought you said.
Uh-uh.
All right, so Carmen.Banks, I believe you have it already at 36 District Court is where you send it. And Ms. Gibson, if there's anything different about the document when you receive it, then come back in on the Zoom at any time and let me know. Because the intent here is to make sure that the document meets with what has been agreed. All right? That's
Thank
it,
you, Your
Ms.
Honor.
Gibson? All right, good day to both sides. It looks like
And for the information of the court, I missed a little bit of that because I had my earphone out because I was trying to get on the phone with her counsel. Nobody picked up. I left a voicemail message.
well, you're talking about Gibson. I was dealing with the Jenkins case. And I'm coming
Oh,
right
I
back.
thought I just heard you say Gibson. I'm sorry, Your Honor.
If I did, I meant to say Jenkins.
Thank you, Your Honor.
The Jenkins case is resolved, and I'm coming right to you, counsel, on the Gibson matter. All right, so counsel, regarding Jefferson Capital versus Sheila Gibson, and I know Ms. Gibson is on the Zoom as well. Can you update me there, counsel? What's going on?
Yes, I did contact Charles Hemming's office. I didn't get a hold of anybody. I left a voicemail message, saying that we're currently at a hearing at 36 District Court and what the case number is, and please give me a call, but I haven't heard anything back.
Excuse me, Your Honor, I'm appearing for Mr. Hemmings this morning.
All right, I've come to several times. All right, Madam Counsel, your appearance at this time, please.
My apologies. For some reason or other, it's not coming, your court's not coming through real clear this morning. Diana Zagararis, P32106, appearing for Mr. Hemmings on behalf of Sheila Gibson.
All right, thank you, Madam Counsel, and good morning to you. I hope that we're getting across a little bit clearer here. All right, so of course this is set up for status and scheduling conference, essentially a first hearing regarding this matter. My typical process is to set this up on some type of scheduling order. Have the parties had opportunity to talk about this and talk about resolution or anything along those lines?
Your Honor, there has been some discussion about settlement. I can see in the notes. I'd like to see if we could go into a breakout room and potentially work something out.
All right. Madam Counsel.
Hello?
Ma'am, you're interrupting my hearing. Madam Counsel, that makes sense to you? I'm gonna send both of you into a breakout room and see if you get some discussion going in this regard. You want me to send Ms. Gibson in there as well? Madam Counsel, are you able to hear me?
I can hear you, Your Honor. I don't think they can hear you.
I have some difficulty. I don't know why, but this morning, I'm a little further out from Detroit. Maybe that does it. And it's overcast. Sometimes that is not helpful.
Got it. That may be a part of it. So what I'm going to do is I'm going to give you a signal for a breakout room so that you and Mr. Bankston can have a discussion. Would you like for me to send your client in with you as well, or you want me to wait on that?
That would be fine. Yeah, the lady thought my client looks like she would like to join, and I don't have any aversion to that.
Got you. I will make sure that happens. And Ms. Gibson, I'm sending you a notification to go in the breakout room with your lawyer. So just click in the device on your phone. I'm sending it to you right now. All right, the court calls case number 22-179438, This is Earl Gray versus Elmhurst Homes Incorporated. The last time this matter was before the court was set for a status conference. The plaintiff strike that the defendant appeared without counsel, and because the defendant is an incorporated entity must be represented by counsel. All right, do I have Mr. Earl Gray on the Zoom?
Yes, you do. I'm here.
All right, good morning to you, Mr. Gray. For Elmhurst Incorporated, please.
Yes, I'm here, but our attorney is on his way. He said he'll need a couple minutes.
All right, very well. So I'm going to pass on this matter for a moment, and we'll come back to it in hopes that the attorney for Elmhurst is on the Zoom.
Okay. Thank you.
Mr. Gray, just stand by, sir. We're coming right back to you. All right, the court now calls case number 22-242-908. This is Melvine Lewis versus Randall Brown. The matter is before the court where a motion was filed that the court did take under advisement. Let's see what happened here. And set it for a hearing. That is a motion to dismiss in lieu of filing an answer in this matter. All right. Your appearance for, well, let me see if I have Melvine Lewis or counsel for Melvin Lewis. Say something at this time. Last name Lewis on case number 22-24-2908. If you're on this Zoom, please say something at this time. All right, the person that has the is there, you are not connected to the audio. You're not connected to the audio. Yeah, I can't hear you because your audio is not connected. You may need to dial back in. You may need to hang up and connect to the audio because you're not connected. Do I have? So I'm looking for Melvine Lewis. If you are trying to talk to me, you are not connected to the audio. Now let me ask the lady that I see. Okay. Just one moment. Do I have counsel for Randall Brown?
Yes, good morning, Your Honor. Adam Neal on behalf of Randall Brown.
Thank you, Mr. Neal. Go ahead and put your P number on the record, if you will, sir.
Sure. It's P69146.
All right, thank you, counsel. And counsel, I think there's a lady that's giving something of a signal. Tell that on her device is not connected to the audio. So I'm going to give her a moment to try and maybe that's there now.
Understood, Your Honor.
I'm looking for Melvine Lewis. Say something if you're there. Yeah, well.
Hi, Your Honor. How you doing? I have a question for you, if possible.
Are you Melvine Lewis?
No, I am not. I'm trying to
All
make
right.
sure I'm in the.
Not right now, ma'am. Not right now.
Okay. Yes, sir.
All right. So, counsel, just give me a few minutes, and I'll come back to this one just to see if that person might be the person trying to get in on this.
Hello?
Oh, thank you, Your Honor.
Who are you,
Hello?
ma'am? Hello? How are
Hello?
you?
Oh,
Who
here.
are you? Not you, counsel. Ma'am, go ahead. You were speaking to me. Who are you?
Oh, yes. My
Hello?
name is Tina Bola.
Not Tina, Lord.
Okay.
Can you hear me now?
Yeah. Who are you?
I'm Melvine Lewis.
All right. Thank you. Thank you, Ms. Lewis. Good morning to you, ma'am.
Oh, good morning. I'm sorry. I was having problems with my phone. I'm sorry about that.
I thought that might be you, and so that's why I wanted you to go through the process of trying to reconnect. All right.
Okay.
So there is the plaintiff, the defendant filed a motion to dismiss the case in lieu of filing an answer. And the law allows them to file such a motion. Have you received a copy of that motion, ma'am?
I'm sorry, I didn't understand what you said. Can you speak a little louder?
Yeah, so I set this hearing up today because the attorney filed a motion to dismiss the claim that you brought. And they're asking the court to dismiss this in lieu of them filing an answer. You received a copy of that motion, correct?
No, I haven't.
All right, so it looks like you're still in Waterford?
Yes, I am.
All right. So it looks like this was sent back in October to the address in Waterford. And that's the same address that I sent this notice to for today's hearing. So you're saying that you didn't receive, they have a proof of service here. You're saying that you didn't receive anything in the mail from Mr. Neal's office, the attorney, Mr. Neal?
I don't recall of receiving anything. I did speak with someone at his office, I think it was, but it's been quite some time ago.
All right, ma'am. All right, got it. 1 second. All right, so there's a petition to dismiss the case. Before I make a ruling on that, I want to make sure that you have a copy of that document so that you can respond to it if you wish to do so. And Mr. Neal, of course, Ms. Lewis has indicated that she has not received a copy of that document. I do see the proof of service, and I've checked the address, and it's the same address that the court used, and Ms. Lewis has been forthcoming in that. She said that that is the factor address, so I don't know what happened. I do know that the claim in this case is some $300. Is it worth talking about that in a breakout room or something?
Your Honor, the issue is I still, pursuant to my motion, I've never been served with a copy of the complaint. So and that's why I asked that it be dismissed without prejudice. Quite simply, I was required to answer a complaint that I never received. So I filed this pleading. I understand small claims. Typically, we would be engaging or attempting to figure out what a reasonable settlement or negotiation, or at least discuss what the claims are. We've never been served, and so I believe the correct action here is dismissal pursuant to our request and our motion. This matter was, we filed this motion back in October. The court set the hearing for a date in November. That was adjourned, and I anticipated it was likely adjourned to permit Ms. Lewis additional time to respond to the motion or to properly serve us. I mean, it wouldn't be proper, it'd be after the fact, but I mean, ultimately, I thought we would address this in the 3.5 to 4 months that has transpired since the motion was filed. But it hasn't, and I thought perhaps the court had given us a second date in December that was then subsequently adjourned to today's date. So I think the court is giving her, and I understand, where you're going with the fact that maybe she claims she hasn't received the motion, but it was served upon her, and she's been given an ample opportunity to respond.
Excuse me, may I say something, please?
Just one moment, yeah, you'll get a chance to speak. Yeah.
Oh, okay, thank you.
The same issue, Council, that you raised in terms of getting notice of the lawsuit. The notice, obviously, is a really important issue here. And I was shocked when Ms. Lewis indicated that she had not received a copy of the motion, because the motion is in the name of something that is dispositive. I don't know what happened with all these adjournments. I do know, unfortunately, that sometimes when a matter starts out as a small claims matter, I know sometimes that gets kind of twisted up in the system for some reason. So yeah, I see that it's been kind of lingering along here for a bit. I know that the date in December, I recall that one. That date, I know that date was adjourned. I don't know what happened with the earlier dates. So coming to you for just a moment here, Ms. Lewis. So what they're asking the court to do is to dismiss the case because defendant Randall Brown indicates that they were never served with the complaint. And looking through the file in this matter, I don't see anything in the file that indicates that Randall Brown was served. Go ahead, ma'am. Go ahead, Ms. Lewis.
Yes, Mr. Brown was, it was very difficult for him to get served. I went through the courts and I paid the officer to deliver the paperwork to Mr. Brown. And he told me that he attempted several times to do that. And then he finally called me back and said that, you know, he wasn't going back again to make, you know, to serve him with the papers. He said every time he went to an office where people directed him to go to, he said that Mr. Brown was never there.
Wow.
Yes.
Go ahead, ma'am. I'm listening to you. Okay. So yeah, what happens in those type of instances, ma'am, that does happen. Sometimes people are evading and avoiding service, etc. But in order for a claim to advance against a party, the court doesn't have jurisdiction to hear that claim until it has personal authority over that person, and that comes by way of them being notified of what the lawsuit is. And technically speaking, what has to happen is that when you can't serve the person properly, you can file a petition for alternate service that allows them to be served in alternative methods and means. That was not done in this case. You may still be able to advance your cause in that way, but at this point, the defense counsel is not under any duty to answer the complaint because of the fact that their client has not been served with the complaint. Ms. Gibson, just silence your device while let's do it like that. I'm coming to you in just a moment, Ms. Gibson. All right, so so that sounds like the size of this. It's very clear that that no service has occurred in this matter. And while you and the court officer attempted to do so, once the officer exhausted those efforts to serve, then what was supposed to happen is an affidavit indicating that the defendant could not be served and the defendant was avoiding service should have been filed with the court, and then a petition for alternate service. None of that has occurred. So the attorney filed a motion to dismiss this case on that basis that there is no service, and that motion is proper at this time. That does not mean that you cannot bring the case back if you decide to do that. If you bring a case back, you will have to make sure that the person that you're suing gets sued with the document. So this case at this time will be dismissed.
Judge, excuse me, I forgot to tell you something, if I may, please. When I was discharged from the hospital that day, and I didn't have any clothes because everything had been lost except for my wallet because I had surgery. And so the following week, I called Mr. Brown's office and I spoke with his assistant. She was a new person and she was very helpful and very nice about everything. And I forgot to mention that to you in the beginning. And I still have the letters that I received from Mr. Brown's assistant, that they were sorry about what happened. And she said that they would investigate everything and get back with me on it. That's why the officer, he did go to Mr. Brown's office and he did speak with his assistant. I think her first name was Tiffany. I do have 2 letters that I received from her. I did keep them. And that's why I told the officer to go to Mr. Brown's office, and I told him to ask for his assistant, and I gave him her name. But then after that, they gave him the runaround as far as where Mr. Brown was located. And I'm sorry I failed to tell you that in the beginning, but I just remembered it.
Yeah, thank you for that additional information, ma'am. Unfortunately, that additional information does not equate to service of the complaint and the lawsuit on Mr. Brown. And they may very well, I don't know, but they may very well, Mr. Brown may very well be attempting to avoid service. But the reality of it is that service is a particular and a specific kind of thing. You had contact with their office, you documented that contact, you documented the conversation, letters have been sent to you, but then you ultimately brought a lawsuit. When you bring a lawsuit, in order for that lawsuit to be properly joined and brought before the court, the person is required to receive notice of a lawsuit. And that notice is a formal thing. It means that the court officer goes out, serves the person and files an affidavit that that person has been served. If they're unable to do that, then they can submit an affidavit of non-service and petition the court for alternate means of service. And that's, I think, what has not happened here. And if you're going to bring the case, whenever you file a lawsuit, you will have to get service over that person in order for the court to have jurisdiction. So the court doesn't have personal jurisdiction over that individual because that individual has not been served with the complaint. And so that's where the case breaks down at this point. You had contact with that office before, that's a good thing. But once there's a lawsuit, that is totally different. Totally different from any other action that may have been taken. And there are rules and requirements that have to be met whenever there's a lawsuit that's been filed. So the case is dismissed. That dismissal is without prejudice, meaning that you could refile the case. Even when you refile it, you will have to make sure that the person either gets served or that you exhaust the methods of serving them and then file a petition for alternative service methods. And the court will rule upon that. All right. The case is dismissed at this time. The reasons indicated the motion to dismiss is granted at this time. But I wish both sides well. Good day to you. All right. Thank you, Ms. Thank you, Ms. Tina. For your patience. What are you asking of me, ma'am?
Yes, sir. I was trying to find out if you've already called Desmond Williams, because I believe you are his judge today. And if not, if I should stay on longer.
I don't have that.
I'm sorry, what did you say now?
She said Williams.
What's the name again?
I was told you had Desmond Williams in court today. He's in custody.
No, I don't have that case. That's a criminal case. A person that you said they're in custody?
Yes, sir.
Yeah, you're in the wrong courtroom. This is, all I handle is civil cases, lawsuits and stuff.
See, they
So-
told me, is there another Coleman as last name of Your Honor?
There's another Coleman, but that Coleman is on civil too. Let's try to find out. What, do you have a case number, ma'am?
No, I do not.
Okay, well, Madam Clerk, is there anything we can do to help her? Because you holding up my hearings, other people.
Tell me the dial 965-4335.
965-4335.
Yes, ma'am. And they should be able
Thank
to
you.
give some- All right, thank you, ma'am. Good day to you.
Thank you.
Your Honor, if I might, real quick, Adam Neal on Lewis v. Brown. Do you, is the court going to issue an order, or would you like me to submit one?
I'll issue a motion so we can move this forward. All right, thank you, Counsel.
All right, thank you, Your Honor.
Judge, may I ask you a question?
Who are you? Oh, yeah. Yes, ma'am. Very quickly, ma'am. I have to move on. Go ahead, ma'am.
Yes, I understand that. But you know, when I went in the hospital and had surgery, they put all my things in a bag, and they said that they put it underneath the hospital bed.
Okay,
And you know, the thing that bothers me so much about this is that those were.
I'm sorry, ma'am. I had to interrupt you. I have to stop you because you're presenting to me potentially evidence that you might have to present in that case. And I'm not permitted to hear that in a one-sided manner. The problem is not your underlying case that you may have. The problem is that the lawsuit is not properly before me because that the defendant has not been served. Your claim may be a valid claim. You may have something that can be proven before the court. The court has to have jurisdiction over the person that you're suing before I can make any decision or have any involvement in the case. And that's the problem. The problem here is that, and I'm sure you didn't know, but once the officer was not able to serve that person, then you would have had to file something with the court asking for the right to serve that person in an alternate way, such as by certified mail, such as by publication, or by taking it to the door of the office. Without that, you would not be able to advance the claim in front of the court. And that's the problem here today. I hate to cut you off, but I can't hear the stuff that you're talking about now because the case is not properly in front of me. So I wish you would update you.
Your Honor, if I may, there is a process within the facility for these types of issues, and I'll speak to my client. Hopefully we can resolve this going forward. So
Yeah,
we'll try to reach out to Ms. Lewis.
Yeah, that sounds good to me. I was thinking that it has to be, because I saw the DMC or something connected to this. Maybe there's an internal way to drill down on those issues, but again,
Yeah.
the court.
We just had to address the legal part first, and then we'll hopefully we'll be able to get to the substance here.
All right, sounds good. All right,
Thank you, Your Honor.
Good day to you as well, Ms. Lewis. All right, thank you. So I had somebody out, Madam Counsel, and Ms. Jenkins, I believe, is back regarding just one moment. Gibson, I should say. All right. So welcome back on the suffix 2469 Jefferson Capital versus Sheila Gibson. Somebody go ahead and update me regarding that matter.
Good morning, Your Honor. Michael Banks, DNP 69778. We were unable to reach settlement, so we're going to have to put some dates on the calendar. We're asking for 60 days of discovery.
That is correct, Your Honor. Diana Zagorowski is appearing on behalf of Ms. Gibson.
All right, very well. I will go ahead and set it up and give you just about 60 days of discovery, bringing this matter back on the 16th of March, 3/16. And that's going to be at 9:45 a.m. That'll be the next action date regarding this matter. You'll get a scheduling order in the mail from me. That scheduling order will allow discovery to be open through that period of time, through that date. It will also allow for the filing of motions under a schedule given by the court. And then I'll review the matter on the 16th to see how far you've gotten along, and we'll see what happens at that time. So,
Your Honor, you said March 16th at 9:45 a.m.
correct, so it's 3/16, 9:45 a.m. And you'll get scheduling from me in the next few days in the mail.
Thank you, Your Honor.
Right.
Very good, Your Honor. Thank you.
All right, the court is back on the record regarding the Earl Gray versus Elmhurst Homes Incorporated. That's the suffix 9438. Elmhurst Homes Incorporated was their counsel, Earl Gray. Mr. Earl Gray is present in the hearing, and as is Ms. Betty Smith. Your appearance for Elmhurst Home.
Good morning, Your Honor. Warren McAlpine appearing on behalf of Elmhurst Home Incorporated.
Thank you, Mr. McAlpine. That is the suffix 9438. And your P number, if you will, Mr. McAlpine, regarding
52522, Judge.
All right, thank you, counsel. All right, so I think I initially set this up for a status conference in this matter. Because I received something that I think was offered in the nature of an answer, although it was not a formal answer to this matter. So, Mr. McAlpine, give me an update in terms of what you see.
Judge, I was recently retained. I did see the documentation that my client provided to the court. I did inform Elmhurst Home that was not the proper form to answer the complaint. That said, we're ready to proceed as of today. Probably we're looking for either an adjournment or some dates.
So are you going to be amending or filing a supplemental answer to complain in this matter, counsel?
Yes, Your Honor, and at some point in motion as well.
Very well, let's see. So it looks like this is a claim where the defendant is claiming damages of $25,000. Is that correct, Mr. Gray?
Yes, sir. And I'd like to add, Your Honor, that the defendants have failed to appear the first hearing, and the court allowed or set forth a default judgment, and the defendant appeared without an attorney, and here it is today. They appeared and the attorney was late. The court has been more than patient with the defendants, but it has been fundamentally unfair to myself. And I filed a motion to enter a default judgment. And I want to know if the court has received that. And if so, I would like for it to be entered today.
Well, your notion of the court being fundamentally unfair because of the fact that a party appeared without the presence of an attorney and was informed to bring an attorney in. I guess I understand that you would say that because you don't know what you're talking about. There is no basis for an entry of default. Ms. Smith has been present in both hearings, and when instructed that she needed an attorney in order to advance this claim, an attorney has appeared. So
they didn't appear at the first hearing.
But yeah, well, we know that. You want to tell me something different?
I'm trying to understand you. Why
it's
not
very simple. I think it's very simple to understand. I think you're having a hard time hearing because you don't want to hear what I have to say. The fact of the matter is that when Ms. Smith appeared at the previous hearing, she was informed that they could not proceed without an attorney. If she appeared here today and didn't bring an attorney today, then that means that they decided that they don't want to have an attorney involved and they can't proceed. She brought an attorney. Now, you can dislike that. Who cares? And you can file something if you wish to appeal my decision in this regard, whatever you desire to do. But the notion of unfairness, it reflects a fundamental lack of understanding as to how matters proceed.
Oh, I understand. I understand very.
I didn't give you the opportunity to talk then, so until I give you the opportunity to talk, you're not permitted to say anything. It seems to me that you have a claim that you'd like to advance before this court. That claim yet exists before this court. You filed an action. The other side, they've got to decide how they're going to respond to whatever it is that you filed, and a decision will be made as to whether or not you can prevail in your claim. Now, my attempt was to ask you about what the nature of your claim was, but I see that you want to talk about something else. So what I'm going to do is I will go ahead and I'm going to set this up on a discovery schedule, counsel, and a part of that is that I'm going to allow you to amend your answer if you choose to do so, as the court rules advise that amendments are to be freely allowed where justice so requires. And as you believe that your client's document that was filed does not meet all the form of an answer, you may file a response as the court rules will allow you to do. In addition to that, Mr. Gray also has the benefit of the court rules. If Mr. Gray believes that on the filing of your answer or for other reasons that he wishes to amend his complaint, he has the right to do that because the law allows him to do that. Amendments shall be allowed where justice so requires. So if you file something that he wants to amend, he'll have the opportunity to do that as well. All right. And this is all the process of getting the matter properly in front of the court. We haven't even dealt with the underlying issue yet. The underlying issue is what this case is about. This is the process of coming in front of the court. So I'm going to on the 20th of March, 3/20/23. That will be the pretrial conference date. The parties are allowed to engage in discovery, exchange of information between the parties during that period of time. If you receive any interrogatories, questions, requests to admit any documents along that line, or even a request to appear in a deposition, either party is required to do that during the period of time that the court is allowed under the court rules for the parties to engage in the practice of discovery. Also, during that period of time, the defendant will be required to amend its answer if it desires to do so. The defendant will have the first 14 days of the set period to file any amendment to its answer. Defendant amends its answer, the plaintiff has the right to amend its complaint for 14 days after the filing of the answer in this matter. The discovery process continues throughout, and I will review this matter on the 20th of March, 2023, and that's going to be at 9:30 a.m. All right. I wish both sides well. We'll see you at the next hearing.
All right, thank you, Judge. Have a great day.
All right, good day. All right, this is case number 22-188048. This is Credit Acceptance Corporations versus Sade Jenkins. The matter is before the court on the filing of a motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Sandra Francis on behalf of plaintiff P74229.
All right, thank you, Madam Counsel. Good morning to you. All right, do I have Sade Jenkins on the Zoom? If you're here, say something at this time.
Yes.
All right, good morning.
Yes,
I see you. Good morning to you, ma'am. All right, so
Good morning.
I received the answer in this matter, and I think I had a hearing on this on a previous. There was something about a bankruptcy petition that was filed. I believe that's what I saw, but it was dismissed. There was not a discharge that was issued. So tell me what's going on here. Well, let me start with Ms. Francis, please. You may, ma'am.
Your Honor, we did receive the defendant's answer as well, and as you indicated, the bankruptcy was dismissed. So given it wasn't discharged, then this debt would still be owing. I believe the defendant indicated that the vehicle was involved, or it was stolen, but our client didn't. The vehicle was never recovered by our client, given the condition of the vehicle. It wouldn't have made sense financially for our client to fix the vehicle and auction it off. So there still is a deficiency balance owing on this account.
All right, now, Ms. Jenkins, you understand what's going on here, ma'am?
Yes, I do understand what's going on.
All right, what did you want to talk? Did you all talk about trying to solve this or settle this?
What ended up happening is after my case got, how did you say dismissed, not discharged, but dismissed, after I wasn't working anymore, they sent a letter of saying that we could settle with $1,080. I wasn't working at the time. By me not working, I can't tell you I can settle something and I have no income coming in. I just had a baby that time as well. So when I called them and I explained to them what was going on, they said this is a one-time offer. I said, well, I can't deal with this offer as of right now. Next thing I know, that's when I got a letter saying appear for court, and I appeared for court from you, and I believe it was the end of September, beginning of October, and I was having a baby the end of October. I have not been able to go anywhere due to the fact that my 8 weeks have just subsided. And now I'm also dealing with having to go to the heart doctor. So I don't know. I don't have a time frame to say, well, yeah, now I can go back to work and we can settle something to pay this amount off. At this time, I'm not working. I have 2 children. That's not an excuse, but I'm not working and I'm just getting off of being able to do something. I stay with my mom now. So because of me not having a job or any income coming in.
All right, ma'am. So yeah, I mean, it sounds like, I mean, obviously the hardship issues are very definitely there regarding this matter. The issue and the issue of the proposed settlement some time ago, unfortunately, you weren't able to take that up, as you said, because you didn't have the financial wherewithal to do it. The problem now is that this matter has been brought before the court regarding, regarding an old debt on a vehicle that that you signed off on, and
exactly.
there is a balance that remains on that. I know this transaction occurred in 2016. There's a balance that remains on that, and that's what they're suing on. Whether you could pay it or not is unfortunately not the central issue. The central issue here is whether or not they have the right to move forward to get a judgment for what is owed. And then once the judgment is in place, then they would attempt to collect on the judgment, attempt to find some money that they could get it paid off. All of the collection things would take place after the judgment's in. So kind of my question to you is that, do you have anything you could tell me that you think is a defense to this? Anything that you think is a reason why you shouldn't have to pay it?
What I feel with this vehicle is, like I said, I mean, I understand what she's saying about, you know, the damages of it. I wasn't able to go see the vehicle when they recovered the vehicle due to the fact that they started charging a whole bunch of charges for me as well, just to look at the vehicle. So when at that time, when I called my lawyer, he said, we're gonna surrender this car. I said, that's fine. And then after that, that's when everything else started happening. And when I talked to him before he retired, he told me, I said, did we surrender? He said, I did send him a surrender letter. Now, when I last talked to you, you were saying to try to find something on that. I haven't been able to leave the house. And they actually want, funds to go and pick that up as well. So I haven't been able to look at nothing from my bankruptcy by it being dismissed. Look at it from there to see exactly everything that's going on. All I'm getting, like you said, is this is what you owe. This is what you owe. I tried to, when I went in bankruptcy, to at least try to pay this thing down. And like you say, I ended up being caught up because I couldn't, I had to stop working.
All right.
I spent the.
Yeah, I've heard you, ma'am.
Okay.
And just trying to assess what all of that means in terms of the outcome of this. Ms. Francis, go ahead, ma'am. Anything you wish to say at this time?
Your Honor, just in addition to our motion, what the defendant has stated, unfortunately, I haven't heard a legal defense as to why our motion should not be granted today. The defendant did enter into the contract. She defaulted by failing to make the required payments. So at this point in time, Your Honor, based on that, I would ask that the motion be granted.
All right, so I've listened to the, I've read the motion. I've listened to the arguments in regard to the motion. Now, obviously, this is an unfortunate situation that Ms. Jenkins found herself in, trying to buy a vehicle. The vehicle got damaged. They surrendered the vehicle, but it didn't have sufficient value whereby the plaintiff could take it and put it in auction because of the damage to the vehicle. And so it's kind of like a snowball effect. She attempted to try and resolve this by going through bankruptcy chapter 13. But there was not a discharge that was issued in this matter. So the debt remains, and there is really no genuine issue of material fact. There is no valid defense to the claim. And so under these circumstances, the plaintiff would be entitled to a judgment for the balance that remained on the vehicle. As it relates to issues that occur after that, then to the extent that is brought before the court, a petition for payments or any other protection, then the court will consider that. But at this point, the plaintiff is entitled to a judgment on the claim that was submitted to the court, where the debt was never fully paid. Now, I understand some of the reasons why it wasn't. The defendant was no longer working, was not able to keep the car going, the car was damaged, etc. But the law says that when you sign a contract and you haven't met the obligations on the contract, that a party can seek redress in court. And that's what the plaintiff has done. And so judgment will be for the plaintiff on the terms set forth in the pleadings. The court granted the motion for summary disposition. So they're gonna present an order to me for the entry of a judgment. That judgment is going to be in excess of $5,000. I'm going to sign that. After 21 days, they can try to collect on that judgment. If you don't have anything, they'll never be able to collect. But if you're working or you have a bank account or something, they'll be able to come after it and try and attach it. So that's the way that situation works. If there's something that comes up in the future and you wish to be heard on it, file a motion like for partial payments or something like that, and the court will hear it at that time. I wish you
Okay.
well, Ms. Thank you, counsel. Good day to both sides.
Thank you. You as well, Judge.
If you could submit your order to Ms. Carmen Banks, do you have that email address?
I believe my office should have that, Judge.
All right, make sure they have, so you get that to me right away. I'm reading the door.
Yes, thank you, Judge.
One moment. All right, case number 13-114. Should we try that? It's wrong. Register of active. Okay, 13-114-4301. This is Michigan First Credit Union versus Jeffrey Zoma. The matter is before the court on objections to a writ of garnishment. That writ of garnishment is regarding Ann Arbor Public Schools. This matter is before the court as a result of a judgment that was entered. It looks like that judgment was entered in 2013. It looks like the judgment amount was in excess of $5,000. I don't have a proper register of action, so we'll get one in a moment. All right, your appearance for Michigan First Credit Union. Michigan First Credit Union. Do I have Jeffrey Zuma on the Zoom? All right.
I didn't see that on the docket, Judge.
Yeah. Oh, really? You said they're not on?
I didn't see it on there. But that acquisitions case is here, the attorney is. Bye.
So yeah, it looks like on this matter. Hold on, that was the other one. I just did. This is. Here you go. Oh, I'm sorry. Oh, shit, girl.
Okay.
I am sorry. This was just set for review. Yeah. Okay. All right, thank you. So, now I don't have paperwork on this other one. Let me get them on the record. This is Portfolio Recovery Associates LLC versus Carolyn Thomas, case number 1114301. And I don't think I have that particular file. That's what I was getting at. All right, your appearance for Portfolio, please.
Yes, good morning, Your Honor. Seth Goldner on behalf of Portfolio Recovery Associates. At least I was their attorney of record back when this case was pending, Your Honor. Good to see you again. It's been a long time.
It has been a long time, and good to see you as well. Happy New Year and all those things. Yeah, this 2011, we all remember 2020 coming in, but 2011 is, it seems looking back, that's been 12 years, so that's crazy.
It's several lifetimes ago.
Oh my goodness, oh man. Let's see if I have Carolyn Thomas on here. Ms. Thomas, or anybody representing Ms. Thomas? So I had this set for review today. You know what that's about? I don't have the file, so if you have any inclination.
Well, Judge, I think I can shed a lot of light on this, although I certainly can't answer the fundamental question, which is why are we here? When we got our notice, we had to dig into our archives because, of course, this was a file that we had filed a satisfaction of judgment with the court. I want to say a decade ago, effectively. And so initially, we were very confused as to why it would be on anyone's list of things to talk about. However, we obtained a copy of the ROA from the court. And, if I'm looking back, I'm going to guess that the court had some kind of concern over what took place during an objection to garnishment hearing and how we got to resolve the case thereafter. Maybe I should just give you a dialogue about a quick synopsis of the case, and maybe the court can decide if there's anything left to review.
Let me get the register of action out, because that's what I don't have.
Certainly.
It's 1111431.
I think, Your Honor, the good news is I think in the end there's nothing going on here that's a problem, but obviously let's address it so the court knows that.
Right. It certainly sounds that way. So take a look at it. Portfolio, yeah, which is Carolyn Thomas. Thank you. All right. Okay, go ahead and talk to me, Counselor.
So, Your Honor, at the time I represented this plaintiff, they were an assignee of the original underlying debt, which was pled to the court. It was an Aaron Rents Incorporated debt that had been assigned to Portfolio Recovery Associates. The matter had been placed into collection in my office in 2010. We collected 4 voluntary payments from the defendant before the legal activity intervened. We filed a suit to collect the balance because after the payments we received, there was essentially a couple of voluntary payments and then a plan and then a default and then a reinitiation of the plan. Unfortunately, we had to file suit. Once we filed suit, and this caused me some confusion in our file because there was not only a wage garnishment, but there was a what we call an income tax garnishment, right? But the defendant worked for the state of Michigan. So in my own records, I was trying to sort out, which was the wage garnishment and which was the tax garnishment and which release went with what. So effectively, Your Honor, as soon as we filed suit and as soon as we received a disclosure from the state of Michigan, well, I should backpedal or go back a little bit. We filed suit, met the defendant in court, executed a consent judgment, and that consent judgment was entered on August 8th, 2011 for $1,769.51. That's what was due and owing at the time. After we filed the suit and garnished the state of Michigan, we received a disclosure. It led to some more dialogue with the defendant. We reached a settlement. I think the defendant got a little bit concerned about the fact that we had also filed a tax garn, and I believe there was some confusion on the defendant's mind, like, hey, wait, we settled this matter. Well, that's true, but we had more than one oar in the water, as it were, and it takes a little while to fully disengage. The upshot is, I guess the defendant, she called us and had concerns, and we assured her that, we were all settled up in filing the releases of garnishments, which we did file. And we ultimately sent her a copy of the satisfaction of judgment that was filed with the court. We gave her a settled in full letter. We concluded the matter after suit. We collected $1,544.23. Of that amount, we also wrote off $360.04. And that's why we filed the satisfaction of judgment. Of course, we never heard from the defendant again because from the defendant's point of view, everything was resolved in us too. However, the notes in the ROA seemed to suggest there was an objection to garnishment hearing that I did not attend. I'm a little confused. I mean, I know I personally didn't attend it, but we have notes in our system indicating that we had confirmed a release had already been sent to the court, and we were well on our way to disentangling ourselves from the garnishment business. So I'm assuming the court had some concern over an indication that we failed to appear and we failed to make a refund of the tax garn, But the truth was we released the tax card and never actually received the money because we had resolved the matter some months earlier. So in our file, it's nice and clean. We never had a refund. We accepted less than the full amount due per settlement. We released all the pending garnishments, and we filed a satisfaction of judgment. And my own protocol, Your Honor, is always to send those to the defendant and to send a letter indicating that they're resolved on my letterhead, because I'd prefer not to have defendants coming back to me years and years and years later and saying, you know, hey, I got to prove this debt was paid, et cetera, et cetera. So, you know, I like to provide everyone that, we like to close our files that way. Now, am I perfect at it? Did that get done 100% of the time for every single file I've ever had? I'm sure not. But that's our protocol, and all of my notes indicate that was done. So I'm guessing that I don't know how this old case would come before the court. Maybe there was some concern that we had not done what the court had ordered. I guess at the time it denied the garnishment, but we'd already filed a release, or at least attempted to file one by that date. So, Your Honor, I'm glad you have me here, and I'm happy to answer questions, but I don't know what else to tell you.
You know, I have the same register of action now, and I don't have any greater clarity than that. I mean, it seems to me that the satisfaction that was filed in 2014, and it seems that should be the end of the matter. At some point, there is a review, adjourned on a couple of days. I don't know what that's about. I don't know what the review will be about. And there's nothing to clarify that. So I'm going to deem that the file is closed and that it remains closed. That it should remain closed, that there is nothing that would indicate that there is any matter that is outstanding with regard to this matter.
But, Your Honor, I appreciate that very much, because, of course, you know, when we closed the file a decade ago, we'd like to think it stays that way. But on the other hand, Your Honor, if there had been anything untoward or any concerns, I'm happy to address it. I'm glad we're just confirming everything's fine.
It's closed. There's nothing hanging out there. I mean, you know, occasionally you get the indication that there is some money that was deposited with the court's escrow that needs to be resolved. And I have no indication of an escrow or anything that is attached to this file. That could have triggered something, but there's no notation that there are funds in escrow that need to be resolved. So we will close the file, and that will be the end of it.
All right. Well,
Thank you, sir.
thank you very much for a chance to be here, and it's good to see you, Your Honor. Happy New Year. You as well. Thank you.
Hey, Judge, good morning. That acquisition case that you called earlier, the attorney did check in. It is 897. It ends at 897. Kasha Davis versus James.
Yes.
Keisha.
Oh, yeah, okay, got it here, yeah. It's a couple of times, 22-194-897, JGA Acquisitions Incorporated versus Kasha Davis. The matter is set on for a status conference. Your appearance, counsel.
Thank you, Your Honor. Scott Renner on behalf of plaintiff.
All right, your P number, Mr. Renner, for the record, sir.
73003.
All right, and do I have Kasha Davis on the Zoom?
Yes, Keisha Davis, Your Honor.
Keisha, thank you. Good morning to you.
Good morning.
The main thing that stood out to me in the filing of the answer was that I broke my lease and I paid for it. And then the second thing is that, of course, this is a claim for $2,146 have you all talked about this? Is there some room to try to get this resolved? Or do I need to just set it up on some type of schedule?
Your Honor, through the discussions between my office and the defendant, our notes show that we were working on finalizing a conditional dismissal on a sum of installment payments, approximately half of the amount. Let's see here, the $1,121, and that we've just not been able to touch base to get that executed by the defendant. Of course, the defendant to agree, or maybe there's something different, but that's our understanding right now.
All right, is that about the size of it, Ms. Davis?
Yes, it's been very hard for me to reach back out to them. And by the time I was supposed to reach back out to them before we came to a hearing, it was too late. I had missed the deadline.
All right, so it sounds like to me that the case would be resolved at $1,121, and then there was what was there, a payment agreement, a partial payment?
Yes, with installments of $150 per month starting February 1st or January 31st, January 31st.
Ms. Davis, does that still work for you, or?
Yes, it does, but can it be February 3rd if they don't mind?
Yeah, we can push it to February 5th. Nice round numbers are a little more convenient. Even seeing the last day of the month threw me off, because internally we never do last day of the month, just because of the last day always being different every month.
Okay.
So yeah, so I have on my side to push it to the 5th so that it can
Okay.
be a little more hopefully easier.
Okay.
You know, the 5th is on a Sunday, right?
Yeah, that month it's the 5th is a Sunday. The next month it'll be a Tuesday.
Here at the court, we always send it on Fridays, but that's fine, whichever way you guys want to. All right, so there's a way to get this directly to the court now. If that's the agreement, 11/21, $150 a month, first payment on February the 5th. Then you counsel could put your initials on that agreement and send it to the court as a conditional dismissal. I think it was styled, and I'll go ahead and sign it. And of course, as long as the payments are made, then that will ultimately be the end of the case. If something goes wrong, they could reinstate it and bring it back in front of the court and at least seek the full amount. You understand,
Okay.
Ms. Davis?
Yes.
Is it okay for counsel to go ahead and send that proposed order in to me with your name on it, indicating that you agreed to it in the hearing?
Yes.
All right, so let's proceed in that fashion. That way we don't get any dropouts or delays. Everybody knows what has to be done. And so, counsel, let me give you the email address where you can email that order to the court. That's Carmen. First name is Carmen, CARMEN, last name Banks, BANKS, at 36368, 36th District Court.org.
Did you say Carmen, CARIM?
CARMEN.
Oh, MEN. Okay. Okay, perfect.
All right. Thank you. Thank you, Ms. Davis. All the best to both of you. I'll wait the order. I'll get it signed and it will be sent out.
Okay.
Thank you, Your Honor.
Thank you.
Now, let me ask you a question. When they,
You
you
still on
provide
YouTube?
the email address,
Yeah.
how long do I supposed to wait on those orders?
You should get it. If you don't get that order within 7 days, then let me know. And we can step back and send a notice of dismissal or something along those lines.
Okay, 'cause I have some files that I've been holding on for a minute, and I've been contacting them, and they haven't sent me anything.
Well, we'll